Sedition generally refers to overt actions, speeches, and gestures by a person expressing their discontent towards the established government by provoking violence and hatred against it. Under Indian Penal Code, Section 124A defines and deals with the law of sedition. It has a jail term ranging from 3 years to life imprisonment, and it is a non-bailable offence. This law is supposed to be part of one of the reasonable restrictions of right to freedom of speech and expression, which is guaranteed under Article 91A of Indian Constitution. The history of sedition traces back to British rule when it was used to suppress and oppress freedom fighters in our country. It has always been a topic of controversy in India. The Kedar judgment was passed by Supreme Court in 1962, and that judgment stated that sedition can only be practiced in rarest of the rare cases when the security and integrity of the nation is threatened. The sedition cases have been increased significantly from past few years, especially they were seen in farmers' protest, Anti-Citizenship Amendment Act, and after Pulwama incident. In the recent case of Vinod Dua also, Supreme Court stated that every journalist is entitled to protection as mentioned under Kedar judgment. The major issue with sedition law is its varied interpretation. The words like dissatisfaction, contempt, hatred can be interpreted in so many ways and can be used by police officials and government as per their interpretation. On 31 May, Supreme Court stated that the time has come to set limits for sedition law in India. Justice D.Y. Chandrachud stated, while restraining Andhra Pradesh government from taking action against Telugu news channel under sedition law, that everything cannot be seditious and one should understand that what is seditious and what is not. The Supreme Court dismissed the PIL filed against Farooq Abdullah accusing him of sedition when he talked about restoration of Article 370. There are many such PILs pending in the Supreme Court right now, which also include PILs filed by Editors Guild of India and People's Union of Civil Liberties. The Supreme Court in Disha Ravi case stated that no person can be put behind the bar just because they do not agree with the policies of the state. The Disha Ravi arrest in Greta Thunberg toolkit case raised many questions surrounding freedom of speech and expression in the country. Chief Justice N.V. Ramanna stated that the misuse of sedition law can be a serious breach to functioning of institutions and individual liberty. He also asked the centre that why such colonial era law is still practiced in the country. Attorney General K.K. Venugopal argued that the law should be retained but with proper guidelines and structure. Law Commission Chairman B.S. Chauhan stated that the sedition law should either be rethink or should be repealed. He also stated that dissatisfaction towards the government or its policy cannot be held seditious in nature. The necessity of this law as drafted 75 years ago and its use since independence is highly questionable and it should be re-examined. The freedom of speech and expression is a very essential component of our country, and criticizing the government and its policies for bringing out constructive solutions and mechanisms is the essence of democracy. And such laws as considered draconian can pose a serious threat to democracy of our country. Looking at the recent cases and various judgments, it looks like it's time up for sedition law.